So welcome, everybody. Thank you all for attending both here in person via Zoom. Today's discussion is being presented by the Professional Development Committee of Chicago Women in IP, CHIWIP, and hosted here at Barnes and Thornburg. Today's discussion is assigned to introduce those unfamiliar with design patents to this particular area of patent law. And for those who may be more familiar with design patents, the discussion will specifically highlight the latest developments, including the new design patent bar and recent decisions which impact the obviousness standard for design patent claims. We're approved for 1 hour of CLE credit. So for those in person, you'll see a sheet, a sign-in sheet. Okay, at the front. Hopefully all of you guys signed in. Don't forget to sign out once you leave. And then there are also some forms that they might have been circulated already or you grabbed it. I see most of you do have one. So please don't forget to fill those out. And when you're done, give those back to Iris. She's going to be our moderator today. For those joining us virtually, there will be a sign-in and evaluation form available in the chat. So please look for it. After the panel discussion, there will be a Q&A. So you may ask your question in person or here, or put your question in the chat when we open the floor for discussion. Also, please remember we have a reception after the panel, so please join us afterwards. Now we're gonna get started with, was there any questions about any of these instructions? No, we're good to go? Great. So we're gonna start with the bios for our nice, kind panelists who are joining us today. We start with Robin Boland. She's a senior attorney at Irwin IP, which is a boutique law firm that specializes in high-stakes intellectual property and technology-related litigation. Robin is an intellectual property litigator and counselor with experience in a range of technologies, including computer software, telecommunications, and medical devices. Robin litigates all aspects of patent, trademark, trade secret, and restricted covenant disputes in venues across the United States. In addition to litigation, Robin also counsels clients regarding freedom to operate, patentability, and intellectual property licensing agreements. Robin graduated with honors from Notre Dame Law School in 2008, and prior to law school, she served as an officer in the United States Army. Thank you for your service. Next, we have Calista Mitchell. Calista is a partner at Fitch, Even, Taven, and Flannery. She's a member of the firm's executive and compensation committees and is chair of the firm's DEI committee. Calista practices in all areas of intellectual property law, focusing primarily on patent persecution and on opinions concerning freedom to operate, patent validity, and patentability. Calista has filed hundreds of designs, patent applications in the United States and overseas, and works closely with clients who maximize the scope of protection sought and obtained in those applications. She also regularly advises overseas clients on how to modify their applications before filing in the US to take advantage of differences in US patent laws and procedures to enhance the value of their IP. Calista has been a member of CHIWIP since nearly its inception and has been a member of the board and a chair of several committees over the years, including the mentoring circles, marketing, and outreach committees. And finally, last but not least, we have Sarah Fuckrell-Bernstein, who is a professor of law at Chicago-Kent College of Law. Professor Bernstein's research focuses on the intersection between art, design, and intellectual property law. She's an internationally recognized expert in this design patent law. Prior to becoming a law professor, Professor Bernstein worked as an intellectual property litigation associate in the Chicago office of Kirkland & Ellis, LLP, and served as a law clerk to the Honorable Robert W. Pratt in the United States District Court for the Southern District of Iowa. And we also have our great panelist here, Iris Gomez, who is an aspiring litigator and incoming associate at Locke Lord LLP. Before law school, she earned an MBA and built a fundraising career in higher education. This past year, she competed in the Sol Lefkowitz trademark moot court competition, where her team, her team was named national champions. Wow. Iris has also been involved in Loyola's Education Law Clinic as UFEO Sufiu, where she practices her litigation skills through working with clients on issues such as bullying, special education, suspensions, and expulsions. She was one of 27 students across the nation selected to participate in the Hispanic National Bar Association, IPLI, Institute in Washington, D.C., and is one of 2 students at her law school to be selected as pupil in the Richard Lynn American Inn Court of this year. Iris is currently a judicial extern in the Northern District of Illinois. Additionally, she serves as Chief Justice of her law school's moot court program and supports the school's IP blog, which is IP Bytes, as managing editor. So as you can see, we have our group of very talented and well-credentialed panelists and moderators. So now I'm going to turn it over to Iris.
Thank you everyone for being here today and on Zoom, and to Barnes & Thorburn for hosting us today. Sorry if I missed this and you said it, there's like mics all over here, so if you're having kind of conversations or you're moving papers, they might be able to hear you on the Zoom as well, so just giving you a heads up that that might happen. So I guess we'll start today, and we'll kind of cover a little bit of background, and then we'll talk about prosecution, and then we'll talk about litigation. So Professor Bernstein will cover first her slides on the background and overview of design patents.
All right, thank you so much. All right, so excited to be here. And can I just say, I think this is my 13th year of teaching, and I think this is the first time I've been on an all-woman panel talking about design patents, and I think that's really fantastic in a super male-dominated field. So good job, Shaiweb. Okay. So design patents, what the heck are they? So you may or may not know there are 3 types of patents in the United States. There are utility patents, which protect how stuff works, like this slide to unlock patent that Apple got. There are plant patents, which are the new kids on the block, only from 1913. Very cool, not relevant today. And then there are the coolest patents, which are design patents, right? Which protect the way stuff looks. So here's our statutory subject matter provision. If you've done patent law, you might be familiar with 101, which is statutory subject matter for utility patents. This is the 101 for designs, right? 101 doesn't apply to designs, 171 is what tells us the statutory subject matter. So what is it? Any new, original, and ornamental design for an article of manufacture. That's what you can get a design patent for, subject to the conditions and requirements of this title. So we use all the general stuff in Title 35 unless a different rule applies. So how do you know if it's a design patent? Now, sometimes people laugh and they think I'm joking, but I'm very serious here. I see people get this wrong all the time. I see them get this wrong in their federal court filings, and I don't want anyone in this room to ever do it, ever, right? We're gonna have a perfect track record here in Shaiweb. So how do you know if it's a design patent? The easiest way is to look at the patent number, okay? If there is a D, or for older patents, a DES, that's a design patent. There are also less than 2 million issued design patents. We just got to 1 million recently, last fall. So if you see a number like 8 million something, stop. That's not a design patent. It's absolutely not. So let's review, okay? We see US patent D, okay, design patent, cool. Look, you'll also see on the left, it literally says design patent. I mean, you laugh, but I see this all the time. So like, for example, here is a real life filing, and the lawyers will remain nameless. And they said that they are asserting design patent number 8 million, stop. No, not a design patent, okay? This is actually a real problem though, because design patents have special remedies, and sometimes it actually matters in your pleading and can be a problem. So since people probably know more about utility patents, a little compare and contrast. You've got to go to the PTO to get a design patent. This is not a registration system. You get substantive examination by people with art backgrounds. The design has to be novel and not obvious, but there's slightly different tests. You do have to be a member of the patent bar to prosecute design patents for other people. But the examiners are people with art and design backgrounds. Now, as we're gonna talk about, there's been a recent change. As of January, people who would qualify as design patent examiners, people with art, architecture, landscape design degrees, can actually sit for the patent bar to prosecute just design patents. We'll talk about that a little bit. But basically, we already have this list of majors for examiners, and people with those majors can now sit to take the same test that everyone else takes and only do designs. Really important, the appeals go to the Federal Circuit in 28 USC 1295. When they say patents, they mean patents. This confuses people sometimes. They're like, well, this is in the Federal Circuit. It's not a real patent. They're real patents. Okay, if there's a design patent that goes to the Federal Circuit, I see about one a year, yeah.
You're saying it skips the PTAB?
I mean, if it is in the PTAB, I mean, the District Court Appeals and appeals from the PTAB, yeah. So in 1295, it says that all appeals from patent cases go to the Federal Circuit. This does include, I see, when I used to track this more closely, I saw maybe one a year that got sent to the regional circuit. Luckily, the Federal Circuit's pretty forgiving, but I wouldn't rely on that if I was advising a client. But they do usually let you waive a late appeal, in my anecdotal experience. So sometimes people ask me, why would I want a design patent and not just use trade dress? And one answer is there's no use in commerce requirement for either validity or enforcement. So you don't have to police your design. You don't have to do or sell anything. You can just submit something, and if it's sufficient, you can get a design patent. So those are the main similarities. So what's different? The term for existing design patents is 14 to 15 years, starting at issuance. Okay, it changed from 14, 15 years when we joined an international treaty. But this is a really big difference, is that it's based on issuance. So if I file a continuation or I have a family, they're gonna have later and later dates. You basically restart the clock. So a company like Apple still has a family pending that dates back to the original iPhone. And they come out this year, they get a new 15 years. Things that are different, you can't claim priority to provisionals. There is a 6-month right of priority. That's the real big one. No maintenance fees. You pay your fees once, you get your whole 15 years. Big difference. There's only one claim per patent. Now, you can try to convince the examiner that this is not a different design, this is embodiment. There's no real clear rule. It seems to kind of be, I'm curious what the prosecutors think. There's no clear rule from the outside, but only one claim, potentially different embodiments, but only one claim. And the drawings are gonna be key. There'll be a short pro forma verbal claim that says, I claim a design for a chair as shown and described. And the shown and described is the drawings. So that's going to be really important. So for normal applications, they are not published prior to the grant. There's not the 18-month publishing that we see on the utility patent side. I had to put a little star here because when we joined the Hague Convention, those are going to get published through the international registration system. So this also means no pre-issuance damages for non-Hague applications. So for just regular things, we don't see it until it comes out. If it gets denied, we don't see it. There's a real big transparency issue on this side. And there's that special remedies provision that I mentioned before, which is 35 USC 289. If you remember the Apple Samsung saga, that was the reason that initial verdict was so high, because you could get the total profit for the infringer's article of manufacture, which could potentially be really big. Now, again, this is only for design patents. I see people in court saying that they want 289 damages for utility patents. That is a sanctionably bad problem. People have been sanctioned for that. I wish more people got sanctioned for that. But it's a real big problem because you are not entitled to that if it is a utility patent. Okay, so what kind of designs can get patented? We said a design from article of manufacture. What does that mean? So going all the way back to 1842, there have been 3 types recognized. And that's a design patent for a shape, like this hedgehog shaped dryer ball. You can get a design patent for a surface design, like this fabric design. Or you can get a design for both, like these leopard print grab bars. Now, one thing I hope you will see, especially from this last example, is the standard of creativity is not particularly high. Whether or not this will change after LKQ might be a matter of some debate. Yes, but historically, the rate has not been high, the grant rate's been really high. So how do you claim a design? I mentioned the short pro forma claim, right? So I claim a design for a portable computer. This one's a good one. It's got a whole bunch of different types of lines. So let's look at the different types of lines. You can see in the middle, there's this sort of solid outline around the trackpad. In a line drawing, solid lines are claimed. You'll see also a bunch of broken lines where all the keys are and the general outline and the major contours of this laptop. The broken lines generally mean that it's disclaimed. And if you use these conventions in your patent, you got to describe it. It's got to go in that description part. So here they are not claiming anything in dotted lines. The shape of the keys, the shape of the computer, nothing is claimed. This could be an oval, it could be a square, it could be a triangle, doesn't matter. All that's claimed is that trackpad, right? We see the solid line. And then we see some dot dash lines and kind of a jagged outline around it. So you got these dot dash lines are generally used to show a boundary that does not exist in real life, that you are claiming up to but not including. So everyone's seen a MacBook, there's not like a jagged line around your mouse pad, right? That is a line that does not exist, but they are claiming up to but not including that imaginary line. And then this one has a fourth type of lines, which is rare but also important, which are the oblique lines, which are generally used to show a surface that is shiny or transparent or has some sort of qualities like that. Yeah, was there a question?
What about the difference between the key dashed lines are kind of like little like side
Yeah.
lines? Is that particular?
I think it's an image quality issue. I think those are all supposed to be the same. The image quality has been a really, really big problem with design patents as long as I've been studying this. Now, if you go onto Patent Center and pick the color version, it's actually a high res image, even if it's not a color claim. You can get a super high res version now that we've switched away from, everyone gets a nice printed thing with a gold star. So yeah, so image quality has been a real problem. And you imagine it's a big deal for design patents where the pictures are important. So when in doubt, I pull the high res version, and this one is. So you can also use photos. There's times when it makes sense to use photos, like this design patent for an ornament, which appears to be a little antler on a rawhide string. You can claim designs of indeterminate length, right? Using this little bracket convention. This is a design for a fruit cutter, and I'm not sure exactly how big of fruit they're planning on cutting. Like the Iowa State Fair, I don't know. But this could in theory be much bigger. And for whatever reason, they've chose to make this fruit cutter of variable size. And then you can also claim color. And when you claim color, it's part of the design. Like this, this is one of the patents that got litigated in Apple Samsung, where the color is part of the claim, at least in this asserted embodiment. All right. Yeah.
On the color claims, is there an equivalent like phantom line or dotted line to say all the colors rounded except for this little red speck, or all the colors?
Oh yeah, that's an interesting question. I have not seen that specific thing where where the whole screen would be claimed, but the color from only one icon or something. I haven't seen that. I suspect, I would be surprised to see that, frankly. I suspect that if you only wanted to claim the red icon, you might just do a border around that particular icon and claim the icon separately. It's hard to imagine a situation where you would intentionally and in a sophisticated manner just want to claim a color, but.
Yeah, I think the color itself isn't gonna lend itself to patentability, so you want to go after the icon specifically, I would think.
Yeah, and note that you can make claims of different scope. You can only have one claim per patent, but if I wanted, I could do a black and white one. They will often let you do an embodiment. Here's a color, here's a black and white, like this one had. But you could say, I'm just claiming the icon in this claim, I'm claiming the larger interface in this one, I'm claiming the animated, something like that. Other question? Yeah.
If you're filing for other embodiments, if you were to do them all in the original filing, would you just see a divisional like you would with utility?
Yeah, my understanding, I can't.
I'll talk a
process-
bit about that
yeah.
too, yes.
But if the examiner says, no, those aren't embodiments, they're actually separate designs, there'll be a mandatory.
Yeah.
All right, so I got through those quicker than I thought, so I can take more questions if you want. All right.
All right. Start my own timers. I was gonna say, it's not really fair to follow a professor, so. I just sit at my desk and write patents all day, so. So as Sarah alluded to, there is this design patent practitioner bar as of the beginning of this year. They're really trying to, like, as she said, the patent examiners in the design space have had to have specific degrees for a long time. So now they're matching up the practitioners with similar degrees. That doesn't mean if you pass the regular patent bar, you can still practice designs, but this is opening up a new area of practice to people with these backgrounds. So once you have to take the regular patent bar, you have to go through the same process, and once you've passed, then they give you a registration number that can only be used for prosecuting design patents. And you'll be able to see them. Their numbers start with 700,000, so they have really long registration numbers. And I went.
Better to start with D.
I know, right? That's a good idea. They should have asked you. But if you can go on the website and look up any registered practitioner, and there's currently 13,766 patent agents and 37,562 attorneys. And there are 4 design practitioners as of today. So.
Yeah, I was gonna say, has this actually increased the number of people, like? 'cause
By
I-
4, by 4.
Okay, I was gonna say, I have a hard time thinking of like a fine arts major who just like, is like, I'm gonna sit for the patent bar so I can just prosecute design patents. I don't know.
Yeah, yeah, if you don't mind, at Design Day, they talked about this, because there's people who are watching this obsessively, and I should probably watch what I say on recording, but like, there's people in the patent bar who are like really opposed to this and are kind of like low-key obsessed with like monitoring who's gonna like do this. And so at Design Day, they were saying there were only 3 people. So this is as of when it was like April, May. And they were all people who had gotten special admission. They were former examiners who had special admission. So it sounds like one person.
One new
Which
person.
is one since like recently. I think that it has been slow to get started. I think there has been some confusion. Like a lot of students have contacted me. I think there's been like what exactly counts and what is equivalent. And I think that they're working that out still. And like there are people in the pipeline, but it takes a while, because like even once you sign up, you could take an exam 6 months from now. And so I know that there is interest. There is a non-zero amount of interest. There are a non-zero amount of applicants, but I think it's just been slow to ramp up.
And then you mentioned
firm side?
Was that?
Is there interest from firms?
That I don't know. And you know, the other thing that's sort of a wild card is the agent thing, because I don't know anyone who was asking them to create agents. Maybe you saw it and I missed this, but like it was mostly attorneys. Like people I know who are interested are attorneys who would like to practice. And so I don't know if I don't know what that looks like. I could make guesses based on firm culture.
Then you mentioned there was a couple of like blurriness in terms of what equivalency means versus the patent bar and the design patent as well. So.
Yeah, so there's no category B equivalent here, so you can't say I have enough art classes. It has to be an equivalent degree. And they are doing this on a they're being really careful. I've talked to the people who are doing this in the office, and they're being really careful and methodical and evaluating everything on a case-by-case basis. But like everything has a different name, right? Like my degree says art and design, and it's a studio arts degree. Would that count? It should, presumably. But there are people, like I have many students who are like, I'm not paying $300 to find out. Now, to be fair, you apparently get like $200 refunded if they say no. But still, $100 to find out is not nothing, especially when you're a student.
Yeah, I was interested when I only saw 4, so. Yeah, and these are just some of the arguments that they open this to the public for, feedback on whether this was a good or bad idea. So they're saying that it's gonna increase the diversity of practitioners, lower costs by promoting competition. I would say with the 4, it's probably not accomplishing these goals, but this time next year, maybe the number has changed by quite a bit. So, okay, so I'm really here to talk about sort of the day-to-day issues that patent prosecutors face in the design space, strategy for preparing applications, prosecuting them, that sort of thing. The nuts and bolts of my daily life. So as Sarah said, the quality of the drawings is of the utmost importance when you're preparing an application. You need to be working with a design illustrator who has a lot of experience in this space. Utility design or utility drawings can be more like schematics, and it's not like a literal representation of the object, whereas design patents need to be as accurate as possible. I like to start with CAD drawings from the inventors if I can get them, and I beg for them. So that I'm like, are you sure you can't get me CAD drawings? Because I really love some CAD drawings. But there are illustrators that can, take an object and draw it by hand, but you could run into more 112 issues down the road if everything doesn't match up exactly. So when you prepare an application, you need a whole bunch of views. Whatever number of views is needed to adequately show the design, what you're claiming of the design. So usually that means a perspective view or two, a front, a rear view, a top and bottom, and some side views. If your front and rear view are identical to each other, you don't actually have to submit it twice. You can just say in your little specification that, Big 3 is a front elevation view and the rear view is identical there too. You can say the same thing if it's a mirror image of another view. So you can save a few bucks on, figures from the illustrator if they're the same or mirror images. In more exotic cases, you might want to throw in some enlarged views, and I'll show you a couple examples of that, or sectional views, which I use extremely rarely, but have I? Yes, once or twice. Let's see. So when an application is being prosecuted, the most common rejection you're going to see is a 112 rejection, with the examiner not liking something about your drawings, like the one that Sarah showed. With the lines, they weren't quite identical. Today, an examiner is going to say, well, why aren't your lines exactly the same? Because different dashed lines can mean different things depending on what you have in your specification. Like I've certainly filed applications where I say the short dashed lines are not claimed. The long dark dashed lines are perforations that are part of the claim design. So it's all in how you define what is being shown in your drawings. I get a lot of questions from inventors about including dimensions in your drawings. You don't include dimensions, it's really just what it looks like. I also get disappointed inventors when they see the specification. They're like, is that it? Yes, it's very short. I wasn't skimping. That's really just how short it is. It's just a very brief explanation of what your figures are. You had a question?
Yeah, just, my understanding is that not having dimensions also kind of broadens the claim because it could be any size.
Yeah, it's really just proportions that you're claiming. Let's see.
Proportions are actually you can say, okay, this is 2 to 1, length.
Yeah, and then it's, you got some wishy-washiness.
Well, you don't usually say.
I run into in utilities and the last
Yeah,
one
you
I
don't
do is
typically
on
take a ruler and apply it,
Yeah,
right?
yeah.
Like that's not as far as you go, because a lot of utility people like to measure it out. It's not quite like that. It's just sort of like, oh yeah, that looks about twice as big as the other one. That's the idea.
So on the left is actually a design I worked on. I think it was for a client from overseas. And this one shows the importance of surface shading. So in the US, surface shading is very important to show what you're claiming, and an examiner will give you a rejection if they can't tell if something's a surface or an opening. And maybe that distinction is very important to what you're claiming. Like this one, for example, if we didn't have surface shading on those openings in the floor covering module, you might think it's just an ornamental pattern on the top of the module. And being that that's a key feature of this particular design, that would not have been great. And then on the right is another example of the oblique shading. So this patent is claiming the transparent nature of this mixing bottle, and you can see what's inside it. So there's a lot of options when you're trying to claim something. Because maybe the good stuff's on the inside. So enlarged views, I don't use them a ton, but it's a handy tool to have when you need it. So this is just a patent I found for the string lights. You can see based on the size of what's being claimed, that the detail is hard to see in the regular figure on the top. So what they did was they include a circled portion, and then they include another page of figures where they show all the detail that they're claiming. So then there's no question as to what really the string lights look like. The one on the right, I thought was interesting because it actually starts to look more like a utility figure with all those lead lines and reference numbers, but all of those mean that they've circled these areas and they have included enlarged views of all of those parts. So this is someone who really wanted it, they didn't want indefiniteness rejections for all of these parts of the electric bicycle for whatever reason. So, yeah,
Was this design filed claiming priority to a utility though?
that's a good question. I don't
I
know.
was just gonna say, it looks like,
Yeah, maybe.
I wouldn't be surprised.
Although I don't know if you would have all those enlarged, well, maybe you would. Good question. I will look that up.
I'm gonna take.
Sometimes I just poke around, look for
Yeah,
interesting
if you
stuff.
see a lot of lead lines and stuff, like that often is one that's descended from utility, but sometimes people just don't know too. I mean, I think it would be a
Well, these are
mistake.
lead lines for the purpose of
Yeah.
indicating the enlarged views, but yeah.
Yeah, but I mean, I think it would be a mistake, I'm trying to find a diplomatic way to say this. I think it would be a mistake to assume that everything you see in a design patent application was a sophisticated, educated. Sorry.
No, that's funny.
Maybe like describe what claiming priority over the utility means.
Yeah, so design can't claim priority to a provisional application, but you can actually claim priority to a non-provisional utility application. It's not super common, but as long as you have support in the utility application for whatever views you're going to include in your design pattern, you can claim priority.
Yeah, so if you have all the pictures, say I do have a utility patent claim for my electric bicycle and I'm claiming some part of that mechanics. I mean, I do know people who are very thoughtful about putting all those views in their utility application so that they can use this support and then they can, so you can claim design patent, utility patent, and vice versa, by the way. There's at least one very famous case of that.
Vice versa,
Yeah.
as a continuation or a continuation part or?
As a continuation. There was a case about catheters and the entire invention was it had a better shape. And so there was enough detail in the design patent that they were able to claim with no 112 issue.
I would say the rules differ around the world, so you really have to figure that out. I know we looked into it once for some weird situation, but and Sarah also mentioned the color drawings. Unlike utilities, you do not need a petition for color drawings in a design. You don't have to pay a fee. You can just submit them. You can submit color photographs, you can submit color drawings, and in the supplemental content tab on Patent Center is where you'll find them. So each application, utility or design that has a color drawing of some sort will have that language at the bottom left that alerts you that there's color drawings in the file. I think it's handy if you're doing FTO work to go look in there for the color drawings. You never know what you're gonna find, if not just better quality drawings. And I was doing a design office action once and actually an associate discovered the color drawings in the supplemental content and it actually had information that made like it was meaningful for our response.
Oh.
Like it showed some detail that I didn't realize was there. I was like, oh, that's a good find, good job.
And you said FTO, what is FTO stand for?
Oh, freedom to operate. So when you're trying to help a client determine if they're infringing someone else's patents. So just those shoes on the right show you a couple examples of how other people have claimed it. The shoe on the top, they're only claiming those colored portions. So they have the dashed dot boundary lines around it. So the rest of the shoes completely not part of the claim. It's just the location of these different colors. And then you can see the bottom one, they just took a photograph of the shoe. So much narrower claim.
How close do the colors have to be then in infringement analysis?
Yeah, it's a good question.
We don't-
It is part of the
don't-
claim.
So, well, I mean, the rule for infringement is substantially the same to an organic. How that gets applied, I don't know if Sarah would agree with me or not, but it gets applied differently in different contexts. And so to answer that question, we would kind of actually need to, at least in my opinion, see the design and the accused infringing product to kind of be able to answer that. I
I
don't know if you
haven't
have a
seen that
different
many
thought.
color claims actually get litigated, have you? I mean,
I
Apple
haven't,
Samsung
no.
is the only one that
I
comes to mind. And that was an unusual case in many ways that probably should have gone out in summary judgment, but I haven't, but, you know, yeah, it's part of this larger thing, and I'm just not aware of it being litigated that often, because it's fairly rare. That was a rare case where using the full claim and the full color actually made sense, because the shapes were pretty different. Which is why I think it probably shouldn't have infringed as a matter of law. But to a jury, the color made it look more similar. So that's a good question. Maybe we'll see more cases on that.
Yeah, it is hard, and we've looked up various issues related to designs. There's just not a lot of case law, so there's a lot left to be determined.
So if I could ask a follow-up question, like, so when would you advise a client to claim in color then? Because you don't have to, right? And if you don't claim in color, you get any color. So like, in what cases would you think it's advantageous to do it?
Like I've had some inventions that really don't draw well. So that trying to draw them and do like a grayscale version doesn't really work.
Yeah.
So you put color in, but not to claim it, just to give context to the environment?
Almost like you don't have a choice. But then hopefully you have a couple different embodiments. So then maybe you have like some equivalence around the different color options.
Is color more helpful when you're talking about graphical user interfaces sometimes, because there's fewer views, there's less going on, maybe. I think that's why the Apple has maybe leaned, there's certain products, I think, maybe it's not just GUIs, but there's certain products that the color seems to be more valuable, is that fair?
I mean, certainly if the color is what you did, right? So like the shoe brand Tex has claimed all sorts of colored soles, because like that's what they do, right? There's a unique-ish shape. But like the big thing is the teal soles, right? And so I think that's an important part of the claim. That's the added,
Yeah.
you know, like I can see where there was, the shape was old, but the color was at least.
That's my question.
Like the trade dress helps there, but I feel like for GUIs, that's definitely like, you're not, that's a little bit harder.
Or if there's like a color spectrum or blended
Yeah.
color, I've done some of that where like colors start like a gradient. That's really hard to show in grayscale. Doesn't look very good. And you can use stippling instead of color, and you can claim a contrast in appearance via stippling, like this area is stippled and this one isn't, and then you define that the stippled area indicates a contrast of appearance. So you can try to get away from using color. But yeah, color has been sort of a need to use, it's not as common.
When the design patent goes expired / public domain, if it's related to color, is the analysis any different for trade dress when it comes to like not stepping on your own toes?
So trade dress and trade dress and design patent are two different things,
No, no,
right?
sorry.
So,
I mean,
yeah.
like you have a utility patent
Right.
and then, you know, you want to make sure that your trade dress
Right.
is still like not becoming public domain because your, traffic's.
so
yeah, I was
as
gonna
long
say-
as you've established for trade dress, as long as you've established a secondary meaning for it, then it should continue on forever, as long as you continue to pay your fees.
So I think
and all
what
that
you're
stuff.
asking is like, Is there a traffics for design? And the answer is no. Should there be? Yes, but for whatever reason, courts like don't care. They're like, it's designed, whatever. Especially here in the Seventh Circuit. The Kohler, if you wanted the Kohler case, they're like, yeah, whatever, it's fine.
So when a client comes to us and wants to file a design, there's a lot of considerations right off the bat. It's your budget. Do you want to do all solid lines and have a very narrow claim? Maybe this product isn't super important. You just want to file something. Or is it really important and you want a few different embodiments with partial claiming? What kind of design arounds might someone come up with? Like what part of the object is most important and most likely to be copied? Because maybe we don't claim the rest of whatever it is. And where are you going to file later? That might influence the sort of drawings you include right off the bat. Like Europe, for example, you're limited to 7 drawings. So you don't want something that you can only really draw in, 9 different drawings and 2-3 perspective views or something. You're gonna have to like limit your drawings there. So this one is just an example of a lighting fixture that this applicant included a whole bunch of embodiments. The examiner said they were obvious variants of each other, so let them all grant together. So it's definitely possible to get a patent with multiple embodiments. You can see they all have the same crystal structure or whatever that is. Yeah, that's a little delayed. Partial claiming, the bottle on the left, they didn't care what the whole bottle looked like. The body of the bottle is all in dashed lines. It's not part of the claim. Here, they were focused on the mouth of the bottle. Maybe they, in a different embodiment or a different patent, they filed on the bottle, who knows? The middle one is a watch band. They aren't claiming the watch, they're just claiming the band. So an infringer just could make the band, use it with an entirely different watch, it doesn't matter. And then the toothbrush on the right, it may be hard to see, but the only part of the claim is the sort of grip portion right there in the middle. The rest of the toothbrush, what it looks like doesn't matter. And then this is another example of like indeterminate height. This bottle is actually pretty tall already, so they could have shortened it quite a bit and made it a more meaningful indeterminate height break, if I'm going to be critical. But here they didn't claim the bottom of the bottle, the very bottom. You can see that boundary line maybe a little bit up from the base of the bottle, but then they claim the mouth of the bottle, which is maybe a little narrow. The one on the right is a fence panel frame. Also hard to see, but the far end of the fence panel frame has a boundary line. So the fence panel frame could actually be much, much longer. They're just claiming a shorter segment of it. So you can put your boundary line wherever you want. You can use a lot of creativity in putting applications together, especially if it's important to the client and somebody's inclined to knock it off. Restriction practice, similar to utilities in the sense that if an examiner thinks you have multiple inventions in your application, they're going to issue a restriction requirement. You're going to have to pick one. One watch out for that is whatever you don't pursue, you're losing that embodiment. You're gonna have prosecution history estoppel, so that if an infringer someday is closer to one of your embodiments that you didn't pursue than it is to the one you did pursue, you're gonna have a hard time covering that infringing object. What's I gonna say? So it's the same sort of situation. Was there a surrender? Was it for a reason of patentability? And the courts have taken a much broader approach for designs, in that if you made an election in response to a restriction requirement, that is a reason of patentability. The court has said we're not extrapolating that to utility patents. That was a design specific rule. So you gotta worry about what scope you surrender if you don't pursue embodiments that were part of a restriction requirement. If that makes sense. Yep,
Is that distinction you're kind of alluding to, where like of course chose not to apply it, why there isn't a concern or like a practice of like submarine design patents? Or what, or, you know, part of the reason, I understand we switched from calculating utility dates from from priority date.
submarine,
Like, you know, or like, you know, we evergreen this design, we keep going for continuations.
so I was
Why?
working on a project recently and I came across a design and there were like 150 embodiments. And they had a like 70-way restriction. No joke, like it was that many embodiments. And if they take the strategy of filing a divisional every 2 years, that patent family can last longer than I will be alive. No joke, because like they had only filed a couple so far. So if they stay on that trajectory, they could have patent issuing from that family, 100 years from now.
So it could exist, but it sounds like hasn't happened yet, and it would be like 1 or 2 cases, not like some of the early processor patents that are the patent office is trying to get rid of.
I do feel like this is an area that someday is gonna change, and like these are the current rules, but this is pretty low hanging fruit for like, if you're gonna change a policy, this could be an area to.
Okay, that was kind of.
Cause like that was my next slide was showing you that you can stagger these families. And to some extent, like if you're not expanding it out 100 years, it's not that big of a deal, but if you've really got 70 groups and that an applicant or a person making a product has to worry about your 60 unpursued embodiments for the next 50 years when they wanna, come out with a product, that doesn't seem fair either.
Yeah, I will say, I've looked into the history of this a little bit, and I won't say I've fully exhausted this, but when we change the utility patent terms to do things like you have to publish in 18 months, you have to change the way we're calculating it. Designs were not included, they were specifically excluded, and it's not clear from the public record why. Very strong suspicion that someone called, someone. There's a public choice story here, and like no one was really worried about design patents and thinking about design patents then. And I mean, even when I was practicing, design patents were kind of like viewed as the realm of scoundrels that like is either bad or no one cares about or both, right? So when all that stuff got changed, like somehow someone, got that excluded. There's no obvious reason to do it. And I think that you're right that there's no good reason to keep it that way. I have heard people bragging, I can get you, a design patent for your product for 30, 40 years using this kind of daisy chaining strategy that you're talking about. And I think the Apple iPhone's a great example, right? Like that phone was publicly disclosed when I was a 3L and I'm now a tenured law professor, right? So that's like pretty long. And I think it hasn't attracted a lot of attention yet, probably for the reasons you're saying, that it hasn't been like excessively abused, but it's weird and it doesn't make sense. Some of the concerns about submarine patents are probably not as valid just because of the differences in the way things are claimed. But from a freedom to operate perspective, if something's out there and there's, still one in the oven and you can see there's a continuation pending. Now, remember, you can't see the application because it's secret unless and until it issues. That's a big question, right? If they can go back, because the PTO basically will let you change any dotted line, any solid line, and vice versa without creating a new matter problem. And so I think there are big issues if your competitor is doing this.
Because it's not only can they file a divisional to the remaining embodiments, they can also file a continuation where they broaden the scope of the claim. And that's like even harder to predict what they might do.
Exactly. So there's a real issue for public notice. That's a problem, and for competition. On the flip side of that, if you're a really sophisticated design patent practitioner, it's great, right? Because you could do some really scary and anti-competitive things. But I don't think there's a real good reason for that, other than there was some deal when that went through. That's my strong suspicion, right? I have no inside information, but like that was specifically excluded, and it's not clear from the public record why. If anyone out there knows and wants to talk to me off the record, it's one of my great mysteries.
Not to add more to the concern, but I remember somebody mentioning that there's a significant disparity between the rejection percentage between
Mhm.
utility and.
Yeah, I'll talk about that in a second here, yeah.
Just briefly, what was the 2-year thing you were talking about with the rolling out with the continuations for the design? You were saying every 2 years, was that
Oh,
specific?
like they were sort of on a 2-year path. So like from filing to grant is generally taking about 2 years these days. You know, when I started my career 20 years ago, it was more in the like 6 to 9 months time period, but it's really slowed down. So they have a lot of time to make decisions.
Are there delaying tactics? So on utility side, you can, putz around and keep your application pending, but you're losing term. Is there delaying tactics on the design
That's a
side?
good question. I can't think of any.
The CPA with
CPA,
the
you don't have that,
IDS.
Yeah.
Be hard to do that if you don't get a rejection.
Well, that's why you could just keep citing references.
Yeah, I guess you can keep citing your ideas, right? Like,
But then it's, and then the
Yeah.
cost is
She would
going up.
never
You might
do
as
Yeah,
well-
it wouldn't be
But I mean,
cheap.
but the
Never.
question is, what's the advantage, right? I mean, assuming you had the budget and, the bandwidth, like, why not just file a continuation, and keep them pending, and then you can change the scope later?
There are,
You might not have
Maintenance
that
fees,
much
so-
to mine from.
Is that?
Like you might not have that much, you might not have that many drawings in there, right? So sometimes our,
Yeah, but remember, you can change the drawings. You can
Yeah,
change
that's
dotted
true. You
lines to
can
solid
change
lines
and
and vice
switch it.
versa without having a new matter problem, and that's huge, and that's intellectually bizarre. But
it's literally the definition of new matter.
thank you.
Sorry.
But you cannot add a boundary line that didn't exist before.
Right.
You can
That
change
is-
existing lines from solid to dash, but you
Right.
can't do one of those jagged boundaries if it wasn't there before. So there is sort of limits on what you can do.
Yes.
All right, so I'm gonna go here. So something a little bit different. We're gonna talk about the change recently in the test for design patent obviousness. So first off, everyone knows USC 103, as Sarah discussed in the beginning. If there's no special provision for design patents in the 35 USC, we apply the same thing for everyone. So utility patents, design patents all have to follow USC 103. A long time ago, the Supreme Court considered, and this is not actually in view of a obviousness issue. The court here was actually considering infringement, but the way they handled it was they looked at it and said, well, you can't really be saying that basically, if they don't have the new thing, they can't be infringing, right? So what happened here, people made saddles. There were many different designs of saddles. What they did in this case is they took the front half of one saddle, attached to the back half of a different saddle, and changed a little bit of the perpendicular drop on one portion of the saddle and said, this is new, I want a design patent. They got their design patent. And then the court eventually looked at it and said, well, the only difference is this sharp drop of the pommel that wasn't included in either prior art saddle, but also isn't included in the accused products. And everything else was known. And it was also common at the time for people who were designing saddles to take bits and pieces of known saddles and put them together. Again, the court didn't go so far as to say it was obvious, because my understanding is that did not exist at the time, but that is the basic concept. And this actually then will kind of form what I consider to be the framework of the LKQ-EGM case later on, because you'll see that the Federal Circuit, if you read the case, went back and looked at Smith v. Whitman saddle, even though it wasn't an obviousness case. All right, so what was the standard before? Something that we call the Rosen-Durling test for obviousness, which I understand Sarah had never heard before until that case came out.
I'm not the only one.
Yes, it appears
It
to
was
be,
a great litigation strategy.
it appears to
It's
be
now in Federal Circuit law.
a term that was coined during that particular case. In any event, what was the test? The test was definitely there. You must first identify the correct visual impression created by the patent design as a whole. And importantly, you had to find a single reference that was basically the same as the claim design. That was your starting point, that was your primary reference. And then you could add secondary references to modify the primary references, but only if they were so related to the primary references that they suggested the applications of those features to the primary reference. Now, one of the interesting things about that is the test for design patent infringement is whether or not something is substantially the same to an ordinary observer. So the question becomes, what is the difference between substantially the same and basically the same? Because as you know, the same test for infringement applies to anticipation. So in some respects, what seems to have happened in the cases, and I don't know that this was what was intended by Rosen, was that the anticipation and the obviousness inquiries sort of collapsed into each other. So here are some, you say, okay, Robin, you say basically the same, but like, come on, how bad was it? Primary references rejected under Rosen. Here are some examples. Now, some of these I can look at and I can see some differences, right? The top left one, there's a thicker magnetic strip, there's no hole in the corner, okay? I mean, that's a little picky, but fine. The one up in the top right-hand corner, there's clearly two holes, only one hole. Okay, fine. The bottles, close, but you can see differences. The one in the bottom left corner, I had to go to the case because I honestly could not figure out why that was not, it looks to me to be the same thing, only they colored the other one's cushion brown. And it wasn't a color claim. So apparently that was decided because it was the wrong angle for the images. So the perspectives are slightly different. And so the court somehow found that that affected whether or not it was basically the same. And also you'll notice that the cushions are slightly different. I would suggest to you that that's because they're squishy, not because they're different.
Some good lawyering.
Yeah, I mean, I am doing some defense, I work for design patents. There you go. So, and we just mentioned this. So what is this came out during the actual hearing. So I think Professor Crouch said, you know, between 1% to 2% of applications receive a prior, design patent applications receive a prior art rejection. The patent office said, oh no, it's higher, it's 4%. The actual utility rate, the utility allowance rate is 44%, and the vast majority are initially rejected on prior art grounds. So there's a huge disparity between what happens when you file a utility application versus a design patent application. Most of the time, you're gonna get a patent granted if you file a design patent application.
A note on
Yeah.
Dennis's study, having done some empirical work to kind of update what Dennis did. So the problem is, since we don't see what gets final rejections, we don't know why things that don't become patents become patents. So we can kind of tell you, we can guess during, you know, or we can study. He got that 90% using solid empirical methods that we can replicate. We found that to be substantially true 10 years after Dennis's study. The 1% to 2% was his guess, as I recall, because we just don't know. And now on the data board, the dashboard, there's the USPTO design dashboard, if you've seen this, the rate is much lower now, it's like in the 80s. My hypothesis is that's because of Hague, because if you look at any Hague applications, they're bad. And not, I mean, and for various reasons, right? Because, you know, different, like you said, the international filings vary. But I did think that 4% that they said at the LKQ arguments was fascinating, because that's the most detail we've ever gotten.
Right, and that's for prior art rejection, right? That doesn't include anything that it's a one-to-one rejection because their figures are bad or something like that. Those are just prior art rejections.
I can say from my experience, that number is about right. Like, I rarely get prior art rejections. If I do, it's probably a GUI, a graphical user interface, or the client accidentally disclosed it. And the examiner found it. Those are usually the situations.
You might be seeing more now. We'll find out.
Yeah.
So moving on to the actual issue that was litigated in front of the Federal Circuit. So this is the PTAB decision that eventually was appealed. You can see there up on the top is the claim design, and down below is the prior art. And when the PTAB instituted the proceeding, they said, we find a keen but not exact resemblance between each of the figures and views. And that the prior art conveys basically the same visual impression to a designer of ordinary skill. So they basically said, hey, you got a primary reference here. Congratulations. We'll go ahead and institute. Well, In the final decision, they said that LKQ fails to identify a single reference that creates basically the same visual impression as the patented design. Therefore, you don't have a primary reference, and they didn't have to go any further. And it seems to me, based on my review of the case law, and mine has not been as extensive as Sarah's, but that's what happens to most failed obviousness challenges, is it died right on the Rosen question, whether or not it's basically the same. Because as I said, kind of collapsed into the anticipation question. So there was a panel decision. Basically, bottom line, they said they didn't really have the authority to overrule Rosen-Darling. That's basically it. You can look at this later, but we are running out of time. All right, so the en banc decision. Basically, what they said was, well, LKQ has argued that this doesn't really jive with Graham and KSR, which, as all of you know, KSR in particular says that we shouldn't have rigid rules. It's a flexible approach. We have to look at everything. Probably shouldn't be kicking obviousness challenges because there's one reference that isn't basically the same. So they went through, they looked at that. I think, because they knew if it went up to the Supreme Court, they would get a reversal, said, you know what, we're gonna follow KSR. When there's a rigid rule that limits the obviousness inquiry, it errs. And both the Rosen requirement that you find a primary reference that's basically the same, and what we call Durling's, but what had been in the law before Durling, the so related requirement was basically the same as the TSM test that was expressly rejected in KSR. So what do we use now to determine whether or not a design patent is obvious? The same rules we use for utility patents, which for me, someone who practiced mostly utility patents until 3 years ago, was like coming home. I was very excited to hear that. So what are the Graham factors? We probably all know this already. Scope and content of the prior art, determine the differences, determine the level of ordinary skill, and if there are secondary considerations, you need to consider them, right? Now, one area that LKQ-BGM pointed out that may be tricky for design patents in particular is whether or not prior art is analogous art, but not the first step. The first step is whether it's in the same field of endeavor, right? Look, if you're trying to invalidate a cup, try to find some prior art that's a cup, right? Then you're not gonna have a problem with whether or not it's analogous art. You could probably have a coffee mug. That's close enough, right? The question is, when we get to what is reasonably pertinent to the particular problem the inventor is addressing, because that requires some inquiry into what the problem is that the inventor is addressing, and there is significant, I will say, disagreement about whether or not people who are designing things that can be, turned into a design patent are even solving a problem. So if it's you and you're trying to invalidate a design patent, find something that's very similar. If you're trying to invalidate a chair, try and find a chair. If you can't find a chair, find a table, because people that design chairs also design tables. And as long as you keep it kind of that simple, the case sort of suggests, oh, this is going to be developed as the law goes forward. And I actually think that's going to take a really long time, if ever, because I think most litigants, people in my position, are just going to say pencil to pencil, or maybe pen to pencil, right? But they're not going to say airplane to pencil. That's just not going to happen. And then there's also the KSR test, which that is very small. I should fix that. But we also all know KSR at this point. There's a bunch of different reasons why a designer of ordinary skill might modify a primary reference. It's all outlined in KSR. You should go take a look at that. That is that.
So.
I'll turn it over to Iris.
Thank you. I have a few questions, just discussion about the recent changes. I'm gonna open the floor up for more questions, and then if you are on Zoom, feel free to put it in the chat and I should be able to see them if all goes well. But I'm curious to hear your opinion on this decision. Do you feel like this was a break from tradition or a natural progression to see this happen?
think I already answered that question.
You're brave, yeah.
Yeah, so I guess for the record, my firm was involved in the LKQ BGM case. I personally I'm not on the record of that or anything like that. So I did not personally work on the case, but my firm certainly had a lot of involvement in it.
Yeah, I felt like picking a Rosen reference, if I got an art rejection, that was my point of attack, because I'm like, oh, they're taking it so literally that it has to be almost identical. So I can find some differences and I can make a list of all those differences. And after you see my list, it's not gonna look so similar anymore.
Yeah, which is what GM did very successfully below, right? So as somebody who's not involved in the case and has tenure, I can be opinionated, right? So, and I've also been thinking, so like my first article on design patents was on 103, right? And so I've been thinking about this for like a ridiculously long time. And the problem was with the way Rosen was being applied was, as Robin was saying, starting to look a lot like 102. So the test under 102, does it look the same or is it basically the same? And one would think there should be some blue sky in between the same and basically the same. And yet you've seen her examples, right? And again, like, I mean, that chair one's wild, right? Because I mean, you know, again, like they're not identical. There's no anticipation problem. Like, but we could have a conversation. And I think frankly, your case, right? Like LKQ is a really great example. And when I do this presentation, I have one slide, which is the picture from the front page of the decision that shows the references next to thinking. I'm like, if this isn't basically the same, I don't know what is. So like the court didn't actually have to overrule Durling or Rosen or anything. It just had to apply them better. Like they did, but like it was really hilarious reading the decision because I think you're absolutely right. It reads like we're still being recorded, whatever, I don't care. It reads like they were specifically really trying not to be not to avoid a cert grant. And it also reads to me, if I read between the lines, like there was one or two strong objectors to just blanketly taking the LKQ position. And so there's like weird little tweaks where there's like, it sounds like they're trying to say, oh, but it's not really that bad, or oh, really not that bad, in ways that will provide fodder for litigators for years to come. But one thing that was really interesting about that KSR says you can't be rigid, right? And they were clearly applying Rosen very rigidly. And they were like, oh, well, you know, unfortunately, this has been applied very, very rigidly. And I wanted to say, by who? Who has been applying it rigidly? Like angry ghost meme right here, right? Like how they were applying it was at least arguably the problem. But it was just a lot easier, I think, to say, no, we're a bad federal circuit. We'll do better, we promise.
So I think the other reason why they overruled it, right, is because there was so much history of applying Rosen in the past, right? So I'm a litigator, right? So like you tell me, okay, we're gonna apply a Rosen, I'm gonna go out and find all those cases. And I'm gonna say, no, look, this one, they said it wasn't a primary reference because it wasn't basically the same, right? I'm gonna make that argument on the other side by basically saying, we're wiping the slate clean, we're going to the exact same standard to the extent we can, because obviously design patents are different, but the exact same standard as we do for utility patents that's been working, right? We're just wiping the slate clean. You can't go back to those cases anymore. You can't go back to Rosen, you can't go back to Durling, you can't go back to any of those cases that cited that. You now have to apply this new standard. And there's even a line in LKQ BGM which basically says, people aren't gonna have a problem doing this because there's a huge body of case law applying these standards in utility patents, which is interesting. But I think that is, they didn't, to a certain extent, I don't think that they trusted us as litigators because at the end of the day, I'm representing my client, so I'm gonna do the best I possibly can for them. I don't think they trusted us to basically be like, oh, but there's that one case that says we shouldn't be doing this anymore, so we're gonna stop.
That's a fantastic point about kind of like the stickiness of old precedent. Like we see that even where the Supreme Court reverses things and all the circuits are like, I don't know. I think my old functionality test is perfectly consistent with traffic's, right?
Everything kind of rolls back a little bit.
Yeah, that's a good point.
And so I think just by using different names, because the concurrence was interesting as well, where the concurrence was basically, we don't need to overrule anything. Why are we using the word overrule? Overrule is too much. And, you know, very much wanted to stick with Rose and Durling and just apply them differently.
Yeah.
But I think the rest of the federal circuit realized that people like me who have mechanical engineering degrees and are trying to represent their client are gonna take that rigid rule and try and apply it if it works for us.
I think that's the most compelling case I've heard for actually overruling. Yeah.
Oh, I'm glad I.
Don't tell my friends who wrote your appellate briefs. Yeah, there's also something that came up that I think is really important in the LKQ decision. So one thing is too, when we're talking about the scope of a design patent, now they said that those references are not close enough to be a primary reference. But they also said that it was not close enough to be anticipated under 102. And they're real close visually. So if you want an idea about how broad a design patent is, that's a really good example that the answer is not very. Because of course, with that symmetry principle, it means that they wouldn't infringe if they came later. So if you want to get an idea of the design patent scope, this is going to be my go-to example forever, because it shows you that the scope is really, really small. And then another thing that's important is this idea of visual description. That was a big problem with Durling. Because Durling said, judges, you need to visually describe what that cup looks like in lots and lots of words. After Egyptian Goddess, the en banc circuit said in 2008, no, we don't want to do big, we don't want you to do claim construction in words because a picture is worth 1,000 words, and judges are really bad at visual analysis. They didn't say that, that's my, right? But so we had this weird tension where for claim construction, you weren't supposed to use words, but for obviousness, you were supposed to use words, and that was weird, and they got rid of that. So I think that's a really
I think most folks just kind of ignored the Durling write it out in words thing at a certain point, but.
I mean, it was there, it was sitting around there.
It was definitely there, but I think most folks kind of looked at Egyptian Goddess and went, probably shouldn't do that anymore."
Yeah, so we talked about like natural progression. I think that
Yeah.
was very clearly.
Yeah, I think we've been marching towards this for a while. I also think, I don't know if you agree, that design patents, we were talking about the term previously, they tend to change a lot slower than utility patent stuff, just because there isn't as much design patent litigation, right? And a lot of this stuff gets worked out in litigation where people like me come up with creative arguments. And then the court has to decide whether or not those are legitimate arguments or not legitimate arguments, and that's how we end up, you know, where we are with the body of law. So it takes longer in design patent world, I think, in part just because there are fewer decisions out there about
I think that's right.
crazy
Fewer
things that
patents,
litigants
fewer
do.
decisions.
Yeah, exactly, exactly.
And I'll ask one quick one and then I will just open it up, but I'm curious, in your different areas, and I think it might be different, where do you see the most kind of painful fields and with this change, like in terms of impact? What kind of like, do you think is gonna, which areas are going to benefit and which ones might see a little bit of suffering?
I see more obviousness rejections in the graphical user interfaces, so that's really the only area that I can see. Just obviousness rejections are so rare for other like objects, three-dimensional objects. So, yeah, it's really.
I mean, I think there might be a lot of, what do I want to say? Challenges filed at the PTAB. That would be my guess. Simply because there are a lot of design patents out there, and as Sarah mentioned, not a lot of them have a whole lot of creativity to them. Some of them do. Like, I'm not suggesting that all, like, look, I'm defense side, but I'm not suggesting that all design patents are not creative. That's not what I'm saying. But there are certainly a lot that don't have a whole lot of creativity to them and look a lot like things that existed prior. And so I do think that we'll see a lot of PTAB challenges on those design patents. It'll be interesting to see what the PTAB does with that, because they seem to have really liked Rose and Durling. So
Yeah, I mean, that's gonna, I mean, I think the PTAB is a really interesting institutional factor here, because like you said, there's not a lot of cases in district court, at least not real regular cases. We can talk about the Schedule A debacle another day, right? But like, we don't have a lot of decisions on the merits, but the PTAB does open up the door to at least arguably more challenges in ways that might produce more law. I'm curious to see what's going to happen to PTO, because I have already heard people who like work a lot in this space, are very smart in this space, are like, okay, so that chair can be your prior art reference. Well, you need to find a record supported reason for every single difference. I'm also hearing people say that you need a record supported difference for the combination of differences, which I do not see in LKQ at all, but I anticipate that argument will be made. So there's gonna be a big fight. I think the actual impact of this is gonna depend on how much courts buy that and what it means to be a record supported reason, right? Could it be I changed the wheel well shape because we changed the shape of the wheel or the size of the wheel? Is that enough? Or do you have, like, that's gonna be a major question in my book. But, I mean, who's gonna win? Experts, right? We're gonna have more fights. Who's gonna win? Billable hours. I mean, but we're gonna have more fights, like, cause in the past, I think, frankly, be like, oh, should we challenge this under 103? And the answer almost had to be no, right? That it wasn't worth your time and money and effort. But now,
And yet, if you couldn't find a 102 reference, what was your other option, right? Like, so, yeah, I mean, I do think where the rubber meets the road in the new test is the reason why you make changes, is the reason why you combine references. And that is an area that will certainly get developed quickly-ish, I'm
I would
thinking.
assume so. There's already
Yeah.
been one decision, right? I haven't read it
Yeah.
exactly. And then
Yeah.
your case is still going, or one of your cases is still
Two of
going. Two of them are still going. I can't keep track of this. But I mean, it's gonna be really interesting. And I think one fascinating thing is what's gonna be going on at the PTO, which will be invisible to most of us, because if there is a successful, final rejection, we will never see it as the public, which is a problem, I think. I mean, frankly, I think one reason, anyways, speak about rules that like make no sense, right? I mean, I think it would be good for us to be able to see those, but we can't unless it's a Hague application. And again, those are public, but those are, I think, perhaps not representative or particularly helpful in many cases. But who knows, maybe we will see some.
Thank you. And then any question? Yes.
Yeah, I'm curious where you guys think, like the secondary considerations are gonna pan out, like just trying to apply that to design is like breaking my brain.
So they were already being applied
Okay.
prior to the change. That's actually the one area that just didn't really change at all. And so now there are certain ones that don't make a whole lot of sense in the design patent context, like longstanding on felt need, right? Like that it could make sense, but I think I think that's one of the ones in LKQ-PGM that they mentioned, like, yeah, we'll see, we'll see, it might apply, it might not, we'll see, right? But that's one area that that's been applied the whole time.
Okay, so you think that's just gonna stay the same?
Yeah, I think has it come up a lot? No, because most of the time you didn't get past the primary reference, so you're definitely not gonna get to secondary considerations. But to the extent you did, then secondary considerations had been considered.
I mean, probably one of the best examples I can think of was Apple Samsung, where the district court thought that the primary references were proper. And the federal circuit ultimately said, no, they're not close enough. But the district court did go through. And one tricky thing I think with designs is because of the partial claiming, you have to show a nexus between what is claimed. And so like Apple would be like, hey, the iPhone's really popular. And it's like, yeah, but you didn't claim the iPhone. You claim this little bitty piece of the iPhone, and you got to show that bitty piece. So I think that the nexus requirement is where it gets tricky for designs. And that's probably the best example I've seen of how courts really carefully look at that issue.
Yeah.
Especially like if you're making that argument to the patent examiner, like secondary considerations is usually our like last option. Cause you're probably gonna lose if that's your best argument. So,
Also, a lot of times you're prosecuting things that are much earlier. I mean, a lot of that unfelt need commercial success is when something's been in the market. It takes a long time. In my experience, it takes a long time for, to gather that data.
and then to have it reach the nexus is
Yeah.
like really
The
hard.
nexus
It's
test
really
is
hard.
really-
Yeah.
Yeah.
Clients usually don't want to be doing that unless they've called Robin.
Yep.
We're already paying Robin's bills. What's it?
And we'll take one more and I think you raised your hand. Yeah.
Yeah, I have a question. Can you talk about who the ordinary observer is? And the
Yes.
real experts?
So the ordinary observer is the primary purchaser of, I'm paraphrasing, but the primary purchaser of the object, essentially, right? You probably have the exact terminology.
Well, I mean, I think the most important thing about the ordinary observer is the ordinary observer is a hypothetical person.
Yes.
Like the reasonable person in torts. They are not the reasonable consumer in trademark law, right? So we can't go out and survey them or get affidavits.
They are made up.
Yeah, so it's basically the judge or the jury, right?
Yeah, I mean, the theoretical idea is the perspective, the primary purchaser of the object, and they're going to give the amount of attention to viewing the objects that they would normally give if they were purchasing it, right? That is the theoretical idea. In practice, that doesn't really happen. I mean, you could say, oh, you know, people buying, I don't know, airplanes look more closely at something than people buying pencils, right? So you could kind of make that argument, or I would make that argument and say, so they're gonna scrutinize it more closely, so they're gonna notice more differences, right? That's the basic idea. But in practice, it really comes down to what does the judge think, what does the jury think?
I mean, that's interesting, right? Because there is some case law in the federal circuit that starts to sound a little more trademarky like that like a sophisticated buyer might look at it different, but I've never seen a case where it actually made a difference as practical. Because going all the way back to Gorham versus White, this is a test of visual similarity. It's not a test of consumer confusion. It's not a test of marketplace confusions, but so I see these arguments and, I've just never seen them go anywhere.
To be fair, they did add a very confusing statement that it would basically, substantially the same, so it would confuse someone buying it into thinking it was one when it was the other, which sounds super trademarky, right? But that's not the way it actually gets applied. And when I think of that, I think of not that they would, but that they might be able to, is kind of how I look at it. Like they would look at it and be like maybe they might think they were the same. But that particular statement, I think, is where a lot of that
is where it
argument comes in.
Okay, so I have an article coming out in December where I spent way too much time explaining why I think that the best, no, you're absolutely right. People read that part of Gorham and that's what they say. They say me trained in the 21st century or late 20th century, that sounds trademarky to me. It was not trademarky then. And if you want to read a really, really long, not that long, a few pages of description about why the best way to read Gorham, including that part, is actually a test of visual similarity, and that the federal circuit's actually been doing that right. It's posted online. You can email me. That'll be a final version soon.
Thank you, and I could probably ask you questions for a long time, but I let everybody enjoy the
We had
food.
a question. We have time.
Yeah.
One more question for Robin. So in practice, when I'm assuming, you were still using experts for developing 103, even before the new test came out,
Oh, yes.
right? And given the new test, do you see what type of role do you see the expert would play? Do they play more of like just laying the groundwork for what's the level of the skill in the art? Or do you see how much weight, like let's say the expert opines that I view from my point of view that, oh, this is very similar, this should be obvious.
Yeah.
Does that
Yeah,
carry the day for the court, or is that more like, I just need you to lay the groundwork, I will determine?
No, so I mean, the obviousness standard is from the viewpoint of a designer of ordinary skill, right?
Yeah.
And so we need a designer, hopefully more than ordinary skill, to explain why it would be obvious. And I mentioned this before, where the rubber meets the road is the reasons why you make changes or the reasons why you combine things. And in my view, and I think most people's view, it's essential to have an expert say that. Because I am not a designer, you do not want me drawing things. And I can't, number one, it would just be attorney argument and it wouldn't be worthwhile anyways. We need someone factually to come in and say, here's the reasons why you would make the change. And that's why LKQ VGM says record supported evidence. It can't be me saying it. It's gotta be somebody who actually does it, saying it. So yeah, no, experts, I mean, I think all patent cases, experts are essential, but certainly still in design patent cases.
Sorry to do this, but is it like utilities where like, I litigate utility patents all the time, but like where your expert is putting themselves in a position, like we have the person of ordinary skill in art, like are they saying it's their opinion is from the perspective of the ordinary observer?
Well, so for infringement, if you have an expert opining on infringement, yes, I would be less putting themselves in the shoes of and them basically saying, I'm a designer, I design these things for normal people. So I know what an ordinary observer looks at because that's part of my job, right? And so that's kind of the framework that they do for that. And then for the obviousness, it's a lot more straightforward because you're looking at it from the viewpoint of a designer of ordinary skill.
Yes, that's a really interesting point because we do have this major difference in design patents, right? So for utility patents, we have the same perspective for obviousness and infringement. In design patents, it's different, right? Has to be obvious to the designer, but look the same to an ordinary observer. So we're not, I mean, I think there's a good argument to be made that it is entirely improper to have an expert opine on infringement, and there are some courts that have gone that far. I think correctly so. There is a little piece of the Seaway case where Judge Dyke kind of does some interesting mental gymnastics about how that applies, and I'm not sure how much of that survives LKQ. But it's sort of an interesting question because we have that disparity.
Thank you. Thank you so much to everybody today in Washington. They'll be around in case you have more questions.